Okay, can you?
Green light will go on.
There it is. All right. Okay. This is the special meeting of the Fairfield Conservation Commission, acting as the Inland Wetlands and Watercourses Agency for the town of Fairfield on September 9th, 2020. I'll appoint Nelson as an alternate to start, and we'll go ahead from there. First item on the agenda is approval of the meeting minutes from August 26th. Anybody have any comments? Anybody that was here have any comments, questions, or observations? All in favor?
Aye.
All right. And next is approval of the recording secretary's bill. All in favor?
Aye.
Then we're going to go into Roman numeral 4, old business, IWPA 2020-21-01, Wisniewski, 1019 Mill Hill Terrace, Assessors Map 243, Parcel 63. Demolish existing house and construct duplex within a regulated area. And the staff recommends approval with conditions. Is there anybody here that's interested in this matter? Okay. Then go ahead, Annette, you have something to tell us?
Yes. In your agenda packets, the applicant has agreed to all the staff recommended conditions of approval. They object to the plantings. They had disturbed, unfortunately, off their property onto the neighbor's property, and I asked for that area to be replanted with the neighbor's consent. And I asked for the conservation easement area that they offered to be replanted. And they would like the areas to remain a meadow. And I think that because there's invasive species there, that they should be replanted with shrubs, native shrubs, so that that suppresses the invasive species growth and we don't have to require an invasive species plan. So I would strongly recommend that you go with the staff recommendation.
Okay, what is the neighbor, the assisted living facility?
Yes.
And he went on their what's that, Maplewood, isn't that the name? Yeah. Yeah, did
Yes.
he go on their property? Is that what you're saying, and disturbed it?
Yes.
All right, and Maplewood wants it meadow or not meadow, they don't care?
In this particular area, it's not adjacent to the existing meadows. It was a woodland and a shrub area.
All right. Anybody have any anything else on that? Anything else in that, or does that wrap up, basically sum up what you have to say?
The rest of it is straightforward. There's an existing house. He's replacing it with a duplex. They've provided necessary drainage and soil erosion and sediment controls. So the rest of it, staff is recommending be approved. This was the only point of disagreement on the application.
All right, so does everybody understand that we have one issue here? Oh, actually, two issues. The first minor issue is, should it be a woodland or restored as a woodland or left as a meadow? And then the bigger question would be is, when we make our decision, do we approve the application or not? But any comments on woodland or meadow?
Does either have a more of an impact on how the actual drainage or any sort of discharge into the wetland soil, does it affect that?
We have never had a successful homeowner area be a meadow. Every time from a homeowner area has tried to be a meadow, it turns into lawn. So from that perspective, the runoff would be accelerated. And in this case, it's not a, right now it's all invasive species. It's not a natural meadow. It's all invasive plants, invasive species.
All right, so what's our consensus here? Should it be meadow? Should it be the woodland as Annette recommends? Nelson?
I would go woodlands also.
Microphone, please. I'm very sorry.
You got to press down. Woodland.
Woodlands.
Woodlands.
Woodlands, if it prevents erosion, like you were saying.
All right, well, that settles that. Now then, having made that decision, what do we think on the whole application? We ready to, Are we all in favor of this application, which the staff recommends with those conditions?
Yes.
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 All right.
Yep.
Okay. Then the next matter is emergency IWPA 2020-21-02 Ambrose ESQ, 180 Hillbrook Lane, Assessors Map 148, Parcel 62. Construct a replacement driveway bridge crossing within a regulated area. And that work's already been done, correct, Brian?
Correct.
And so what we are doing is we're giving it our blessing after the fact.
That's correct.
And this was done when, like in March?
Yes.
Oh, some emergency. All right, anybody have any questions for Brian on this? Is there anyone here in connection with that matter? Should have asked first. Any questions for Brian? Do we understand what was done? Are we all in favor of granting ex post facto this permit?
Yes.
Yes. Yes.
Okay. Next item is new business, is one that's the request of the Country Club of Fairfield for a modification of IWP 2018-19-18, 936 Sasco Hill Road, construct a new clubhouse, et cetera, within a regulated area. The request is to relocate the proposed pro shop / cart barn within the approved disturbance area. See attached. And is this yours, Brian, or is this an ex?
So we had this in front of us about 2 years ago.
Brian, you got to put your phone on.
I've got the whole IT setup going on over here, so. So this matter was before you in 2019. It was for the approval of the clubhouse with the cart barn and addition of a pro shop with associated drainage. The project is currently being constructed. The clubhouse is about 60% done, and the site work is about 80% done. Through the process with that, they determined that they wanted to save the existing putting green, and they asked to move the pro shop just south of the area. There's no impact on the rest of the property as far as drainage or construction. So it's a de minimis request, and there's really no impact based on the modification. Thanks, Jim.
So do they want to then keep like that pro shop more or less where it is right now, just on the
That's
backs?
correct. There's not a lot of room to move everything there, so they're kind of just going back to where it was a little bit.
Okay. Does everybody understand what's been proposed? And your recommendation is that it's not a big deal and we should go forward and allow this de
Approve.
minimis change?
Prove it as a modification to the original permit plan.
All right, does everyone understand that the application before us is to modify the original application, the original permit to allow this change in location of the pro shop? We've heard Brian's explanation, we've had a chance to review the paperwork. Are we all in favor of this? Felicia says yes.
Yes.
Charlie?
Ye- Yes.
Jack?
Yes.
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 Yes, okay. Oh, boy. Hold on a minute here.
I know.
All right. Fine. It's good to be not only on the right page, but on the right agenda. It helps. All right. Next, we have a request for release of performance bonds. Kathy, you want to read those? Have you got it in front of you?
IWPA 2019-20-06, De Laurentiis, 224 Ramrock Road, Assessors Map 72, Parcel 48. Construct new house within a regulated area. Request of Walt Stapleton for final release of $11,100.
All right. Annette, do you have comments, or Brian, who has comments on this?
All the work is done. We recommend it to be released.
Everybody understand what we're doing? We all in favor of releasing the bond because it's a final release?
Yes.
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 Yes, okay. All right. We have public hearings. The first one on the agenda is Fairfield Medical. Is there anybody here on that? Okay.
Are you doing the monthly wetland business update?
I was going to leave that till the end.
Oh, bummer.
All right. And then.
I was just looking at Clan Check, wondering if that will outlive me.
All right. Well, speaking of matters that might outlive someone's term on a commission, even after 10 years, we have the first item on our agenda is continued from March 4, 2020 and August 26, 2020, IWPA 2019-20-11, Fairfield Medical LLC, 4185 Black Rock Turnpike, Assessors Map 118, Parcel 41, construct a new residential structure within a regulated area. Annette, would you go through the time frame on this for us? Well, like when the application was filed, when the hearing was started?
Okay, Annette Jacobson for the record. The public hearing was originally opened in March of this year, but it was technically opened, but no real testimony was had. It was immediately continued. Then with COVID and everything, staff had asked for revised plans. Simultaneously to that, they had a separate procedure on the modification on the 2010 application, which we were in court on, and that was proceeding on a separate track. So this was just continued until now. And it got a 65-day extension. It had the 90-day extension that the governor allowed on all applications. And all of those time extensions, all that we are allowed by statute, run out. There are no further extensions allowed by law that we can continue. So tonight is it.
All right, well, can you just give us the dates just in case someone, I don't want, or
So
can't you do that? Can you-
It was, we also.
When were we deemed to have received the application? Let me have that date. Or don't you know?
I can get the file. So the two times that the public hearing was open was March 4th, and it was reopened August 26th. August 26th, it was continued to now. But no substantive testimony was given at any of those times. It was just always immediately continued. But the file is right behind me. I can open it up and find the date that the application came in the door.
No, that's all right, as long as we know when the application, so they didn't have an extension before, they didn't ask for an extension for the original hearing date. I mean, the hearing, did we open the hearing on time, or was there an extension before we
Yes.
did that?
Oh, we opened the hearing on time, absolutely.
Within the 35 days?
Yeah.
Okay,
Correct.
so there wasn't an extension then, but then we've had 155 days, which is 65 and 90, is that what you're saying? And that's up tomorrow?
Right.
That's up, yes, tomorrow
Okay.
is the last possible day.
And now we've
So,
had,
so just,
No, if I can,
yeah, a little bit more background,
I'm
so.
going to just say, we approved something on this site in 2010. Then we allowed a modification of that in 2013,
15.
2015. The 2010 application was
Extended.
the permit approval was extended for 5 years, starting in 2019. And then at our last meeting, we agreed that we would allow a stipulated judgment to enter, which would allow a new proposal, slightly different than what was done in 2010.
Correct.
To go forward under the 2010 permit.
Permit, correct.
And now we have an application before us, which is different from what we allowed to go forward last time.
Correct.
And, okay.
So the issue is, and, you know, I've been talking to the applicant and the applicant's attorney through our town attorney, and they have no more extensions. They want to extend this out until the court agrees to the stipulated agreement, but there's no extensions left. So, you know, the commission can extend the hearing under, you know, if there's an agreement, but it would be better to just close the hearing now and refile the application and start the clock anew. That wouldn't impact.
Thanks for using WebEx. Visit our website at www.webex.com.
That wouldn't, that's because no one signed into that, because we're all here.
Okay.
That wouldn't, the stipulated agreement and the pending application are not, they're different. So it has nothing to do with having the pending application move forward. They should refile and start the clock anew, just because the timeframes associated with it.
All right. Well, that's background. Now, who's
We
here?
are in difference of opinion, staff, and the client's attorney about that procedure.
Okay. Now, there's somebody's here to make this presentation? And who are you, sir? Oh, you're Paul, okay. Everybody wearing a mask, you don't know who anybody. Yeah, why don't you go stand outside?
Hello?
Chris, so
Yes, sir.
Chris is on the phone.
Can anybody, Brian, can you hear me?
Yes.
Can I be heard? Brian? Okay, thank you. There's a little delay. For the record, Chris Smith of Walter and Pearson. I'm a land use attorney at Walter and Pearson. Can you hear me?
Yes.
This is on the phone. Okay, Mr. Chairman?
Yes?
Okay, good evening, Mr. Chairman, members of the commission. Brian? Can you hear me?
Yes, you're all set, Chris.
Okay, thanks, Brian. Good evening, Mr. Chairman, members of the commission, Director Carey and Assistant Director Jacobson. For the record, my name is Chris Smith. I'm a land use attorney with the... Mr. Chairman? Okay, good evening, Mr. Chairman, members of the commission. Oh, can you hear me? Okay.
We seem to be on a loop here. Whoa.
Director Carey and Assistant Director Jacobson. For the record, my name is Chris Smith. I'm a land use attorney with Mr. Chairman. Good evening, Mr. Chairman, members of the commission. Mr. Brian,
Yes.
there's a delay.
Hold
I
on,
can hear,
let me call you on my cell phone.
not going in real time.
All right.
Hold on. Chris, hold on 1 second.
Is this, how about now, Brian? Is it better?
Hold on 1 second.
I turned off the computer sound.
That should work. That's the
Okay.
issue.
Okay, I apologize for that. So I think I'm in real time at this point.
Yep.
Thank you. Again, good evening, Mr. Chairman, members of the commission, Mr. Carey, Ms. Jacobson. For the record, my name is Chris Smith. I'm a land use attorney with the law firm of Alter and Pearson, and appear before you this evening on behalf of Fairfield Medical LLC, who is the owner, which is the owner of 4185 Black Rock Turnpike. And specifically, we have an application before you this evening seeking approval of regulated activities associated with the development of the subject real property. With us also this evening is Mr. Michael Klein of Davison Environmental. Mr. Klein is a registered soil scientist and certified professional wetland scientist who is very familiar with the subject property. I was able to hear the part of the conversation with Mr. Carey and Ms. Jacobson concerning the timeline, and that's essentially correct. If I can just go through that. But relative to the current, well, I'll get to that. But just, I know the chair had asked at the outset about some of the history. Just very quickly, the commission did approve a wetlands application back in 2010 for substantially the same proposal that's before you this evening. This was modified by the commission in 2015 to accommodate concerns from the TP&Z concerning a development at that point. We then resubmitted this past fall, November of 2019. I'd like to point out that we did receive, with the 2015 modification from the commission, we did receive a related zoning approval, but there was an appeal from certain neighbors that tied it up, and the prospective tenant at that time determined not to go forward because of the time constraints. We did return last fall in November of 2019 seeking confirmation that a further modification was within the scope of the existing permit as it had been modified, and the commission determined that it was not and that we needed to file a new application. In response to that decision by the commission, we did file an appeal in the Superior Court that was referenced before. That's pending in Bridgeport. We'll get back to that shortly. And we did submit a application earlier this year, late January, I believe it was January 28, 2020, and that application is pending before you this evening. As Annette indicated, Ms. Jacobson indicated, the hearing was opened by the commission in March. At that point, the commission, Ms. Jacobson had asked us to review the site relative to there being potential new wetland resources on the property. Mr. Klein and Mr. Allen, another wetland scientist with Land Tech, or a wetland expert with Land Tech, did review the site and confirmed that there were no new wetland or watercourse resources. There was a report done, I believe it's March 9th, 2020, and that should be in the record. As Ms. Jacobson indicated, it was right about then when COVID entered the scene, and we've had quite a bit of delay. However, during that time period, we did work with staff, and in particular, Mr. Carey and your counsel, Mr. Herbst, Attorney Herbst. As Brian indicated before, we did come up with a proposed resolution, which was essentially staying within the footprint of the 2010 wetlands approval. That, along with a memorandum, was submitted to the commission for consideration as a proposed settlement of the pending wetlands appeal that's in Bridgeport. And this commission, at your last meeting on August 26, 2020, did approve that settlement proposal. So we do have that approved. However, we do have to go to court, where the court reviews and approves it. We have not been able to get a court date on that yet. And because of that, we've run up against this statutory time constraint, even with the EO, or executive order, from the governor that did provide the additional 90 days, and that was described to you by Ms. Jacobson. I did submit a letter indicating that we would agree to extend this out to your October meeting in the hope that we could resolve everything with the court. The court would be able to review it. Once that review has taken place and is final, then we would withdraw this application, and the commission wouldn't be required to go forward with the hearing. We did indicate in that letter that we would agree to, my client would agree to waive, first of all, we consent to an extension to take us to your, I believe it's your October 8th meeting. We also agreed, my client also agreed that they would not exercise any right to go to DEP, which is really the only remedy, as you're aware, if the statutory timeframes with a wetlands application are exceeded. It does not result in an automatic wetlands approval, and that we would, again, we would waive any right to make such a claim that it was automatically approved, which it isn't by law. The only remedy is by statute, and that is to go to DEP, which we would agree to not do. However, it's our understanding, if the commission wanted to grant that extension and put it out to October 8th, that would be fine. And it's our understanding that that's not the case, that the commission wanted us to go forward. So we are here this evening to proceed. We did submit the settlement proposal into the record of this application, so that is before you this evening again as a potential feasible and prudent alternative to the application that was submitted back in January. And essentially, as you could probably determine, just trying to cover all the bases and have a complete record for both my client and for the commission if you were to close the hearing this evening. And along those lines, you could close the hearing. You could either vote on it this evening. You could reapprove the settlement if you wanted to, or you could put this over to your close the hearing. You have 35 days plus another 65 days that would accommodate the court proceeding and relative to processing the settlement that you approved last month. So along the lines of completing the record for this hearing, we do have with us this evening, and hopefully he's here. I know he's been texting back and forth, Michael Klein, our expert, who he did prepare a written report when we discovered this was going to go forward. That was submitted yesterday. And Michael, if you're available, if you can take over and just give your opinion on whether either the pending application proposal or the settlement that was approved by the commission at the last meeting on August 26, 2020, involve any type of conduct that would result in an adverse impact to a wetland or watercourse. So with the permission of the chair, I'd like to turn the floor, so to speak, over to Mr. Klein.
Go right ahead.
Michael?
No, he's supposed to be
Michael.
on the call.
He's on the call. I just unmuted him.
Thanks, Brian. Michael, are you unmuted on your phone?
Oh, how about now? Can you hear me?
Yes.
Perfect.
For some, there we go. Okay, this is Michael Klein. I'm a biologist and a soil scientist. My office is in West Hartford. As Chris has mentioned, I've worked, and the commission is aware, I've worked on this property for even longer than the commission has been considering proposed development schemes here. We reviewed the site plan submitted in support of the application 219-20-11, as well as the alternative site development plans provided with the memorandum of resolution of pending appeal, which you approved on August 26, 2020. It's my professional opinion that the regulated activities associated with the site plan that was originally submitted for 219-20-11, as well as the plans that were included with the August 3rd memorandum resolution of pending appeal, are within the scope of the existing wetland permit, the 2010 wetland permit that exists at the site. It's also my opinion that neither plan, either the one submitted with 2019-20-11 or the alternative site plan that the commission approved on August 26th, that neither of those plans would have an adverse impact to wetlands, watercourses, or regulated areas. These plans, both these plans satisfy the statutory factors for consideration and the review and approval criteria in your regulations. Further, I'd just like to point out that the plans provided in the memorandum of proposed settlement, the feasible and prudent alternative, if you will, those plans do not propose any conduct within a wetland, watercourse, or upland review area. Therefore, the plan provided in the settlement memorandum has no regulated activities, and therefore is a feasible and prudent alternative with less, potentially less impact than those that were originally submitted with the application. Hopefully that all came through to you. I muted my TV screen and be happy to answer any questions you might have.
Any questions or comments from the commission for Mr. Klein?
If, for the record, Mr. Chairman, Chris Smith.
Yes, go ahead.
So unless there are any questions, in conclusion, first and foremost, I neglected at the outset, mainly because of the audio problem I was creating with my laptop with the phone, and I apologize for that again. But first and foremost, thank you on behalf of my client and our team for your support relative to your favorable vote on the resolution to the appeal that you provided at your last meeting, again, on August 26, 2020. And again, that has been submitted into the record this evening, just so it's in the record with this application as a feasible and prudent alternative. In closing, we would respectfully submit that neither the application as submitted nor the feasible and prudent alternative, so to speak, which is the settlement that was voted on again at your last meeting, respectfully submit that neither results in an adverse impact and that they comply, any of the conduct complies with the statutory factors for consideration under Section 22A41 of the Connecticut General Statutes and your regulatory criteria. And we would respectfully request that the Commission either approve either application tonight, preferably the settlement, or close the hearing and postpone voting until your next meeting to accommodate the court process. But we certainly would leave that up to the judgment of the Commission. And again, we would respectfully request, based on the record, that you approve either one of the two proposals that are before you this evening. And thank you very much for your time, and thank you for allowing us to participate virtually in this process. We're looking forward to doing it in person without any constraints going forward soon. Thank you.
All right. Do we have anybody on the phone that wishes to be heard on this? Do we know? Does the commission, any of the commissioners have any comments or questions for Mr. Smith or Mr. Klein? Annette, do you want to be heard on this?
Yes, Mr. Chairman, quickly, if briefly.
Go right ahead. And we know who you are, and we know your CV, and you can just submit that for the record, okay?
The staff had prepared a staff review dated February 25th, 2020, and that should be in the record. There were several documents that Attorney Chris Smith wanted submitted in the record. Those documents are in your notepads on your desk, and they're submitted for the record, but I'm going to submit them as well. Alter Peterson document September 8th. For the record, there was a that was a letter. Then there was another email. It's called a Memorandum of Proposed Resolution of Pending Appeal. It's listed as Exhibit A at the bottom from Chris Smith. And a third item is
if I may, Annette, let me just, I think what you're trying to say is that we have, what you're trying to submit for the record is an email from Brian Carey to Tim Herbst, which is dated Tuesday, September 8th. And it has a couple of other, it's part of a chain of emails. Then we have a letter from Alter Pearson LLC, which is Chris Smith, addressed to us. That's dated September 8th, 2020. That's a page and a half. Then we have an email from Attorney Smith to you and Brian Carey with a copy to Mr. Herbst, and that's also dated September 8th, and that has attached to it a memorandum on the proposed resolution, which is dated August 3, 2020. And then we have an email from a Gordon McKenzie to the conservation email, which is also dated September 8th. Is that everything you were going to put in?
yes, I have just one more. Those
Okay.
4 things are in your
Right.
notepads. I'm going to give them to the recording secretary.
Okay. And do you have something else, Annette, that was to be in?
I have one more thing that came in from the public. It's a fair plan, a couple of sentences that would have been for the August 5th meeting, which got canceled, and then it was the August 26th meeting. It was email. I don't know if it was in your packets or not. It's a couple sentences. I don't know if I should read it or just put it.
Please read, first of all,
Okay.
let me ask Mr. Smith, have you seen the email from Mr. McKenzie or the email from Fair Plan? Is Chris on?
He should be on. Chris?
Yes. Yes, Mr. Chairman, was there a question? I'm sorry.
Yes, there was. We've had an email from a neighbor, Gordon McKenzie. That email's dated Tuesday, September 8th. And then we've also had an email on this matter from Fair Plan. Is that also dated today, Annette?
No, this one was dated July 31st.
That's dated July 31st. And my question to you is, have you seen those?
Attorney Smith?
The chairman, I didn't get all that. It didn't come through, Brian. Maybe you could repeat it for me?
There's two items that are going into the record. One is an email that was received on September 8th by a constituent. It came to the general conservation email discussing flooding issues on Black Rock Turnpike. The other one is a letter that was dated, I believe, July 31st. That is just a couple sentences from the group Fair Plan. Neither one of those are expert or witness testimony. They are just.
I was going to say I haven't seen that, and if there certainly if there's any flooding issues, I presume that we would have to address them on the road. We would have to address them with TP&Z. I'm not sure what the Fair Plan email makes reference to, but again, I would just respectfully submit that's why we retain the services of Mr. Klein and also Mr. Allen relative to Atlantic, relative to the issues concerning the resources associated with this. And again, I think the Commission is aware of the fact that we do have a permit. You just voted last November to extend it out 5 more years.
Right,
to, I
right.
believe,
We don't want to get into that right now.
And and we do have to.
We've heard that, we know that, but we're just trying to make sure that you are up to date with Annette's presentation. And Annette's still in the middle of her, just actually beginning her presentation. Do you have anything else to say, Annette? Other than or you're going to rely on your past submissions?
Just the staff recommendation from February 25th, 2020.
Okay. Any questions or comments from the Commission for Annette? Do we think we have anybody online other than Mr. Smith?
No.
Okay, now, Mr. Smith, go right ahead, and you can wrap up now.
I'm sorry. It's just it's difficult to hear you, Mr. Chairman, on the phone. I can hear Brian fine, but it's just not coming through very loudly. But again, thank you on behalf of Paul Richter of Fairfield Medical, who is in attendance this evening, and our team. Thank you for the opportunity to present this to you this evening. And again, thank you for approving the proposed resolution at your last meeting, which again is the feasible and prudent alternative, that is before you this evening. And we would respectfully request that you reapprove that if you do vote on this application that's before you, or at least after closing the hearing, put it over to the October meeting so that we can process the settlement that you voted on at the last meeting with the courts. And again, thank you, and stay safe.
All right, the last thing I forgot to, overlooking the obvious, Mr. Richter is here before us, and I don't know whether he has any comments. Do you have anything to say, Mr. Richter? We shouldn't have, I mean, you've sat through this, but we should give you at least the courtesy of listening to anything you might have to say.
Paul Richter, Fairfield Medical. No, I think all that needs to be said has been said. Thank you.
Thank you. Okay, so I think at this point I am going to close the hearing unless someone has a reason why we should keep it open. Nothing, we don't expect any, there wasn't any last minute submissions, nothing that we need to hear from the neighbors. All righty, I'm going to close the hearing now at this point. Mr. Fitzpatrick, you ready to go? Bill, are you ready to go? Okay. All right, we're now going to go to our next item, which is continued from August 26, 2020. That's IWPA 2019-20-12, Sacred Heart University, Inc., 3135 Eastern Turnpike, West Campus, Assessors Map 22, Parcel 91, construct a new hockey arena within a regulated area. And I think, Mr. Fitzpatrick, you were going to try to submit a couple of things between the last hearing and now. Was that, why did we hold it open? To hear from any case there was any neighbor input? Did we have any?
I did not receive any.
My understanding, there has been no interaction or discussion. So just for the record, Mr. Charlie.
All participants are muted.
Oh, are there any other participants? No.
Mr.
Okay.
Chairman, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Frey, and Bologna. I'm here representing Sacred Heart University relative to the construction of a hockey arena on its west campus, the former GE property. We completed the public hearing presentation at the last meeting on August 26th. At that point, I handed in a sheet with 3 proposed changes to conditions of approval. I am satisfied that 2 of those 3 can be worked out with the staff without any difficulty. The only thing that remains at issue is the quote-unquote oversized detention basin. The commission heard from Tom Daly of Malone and McBroom and Bill Kenny of William Kenny Associates on this issue. The oversizing of the detention basins was not an oversight. It was done intentionally to avoid unnecessary disturbance for future projects. The coverage and floor area ratio percentages for this 68-acre site confirm that additional coverage is permitted on this property of approximately 120,000 square feet. An additional floor area is permitted of approximately 225,000 square feet. There are no additional projects proposed right now, but it seems wise to prepare for the future as we did on the main campus. It certainly is a feasible alternative to shrink the detention basin capacity to that needed for this project, but I submit it's not a prudent alternative to avoid future disturbance of a planted, engineered detention basin on a site which can accommodate, at least on paper, significant future growth is, in my opinion, just good planning. This is particularly true when the majority of the additional land to be utilized for the detention basin is already disturbed, its lawn. In addition, the additional size, I'd like to point out that Tom Daly stated that the area of the increased size of the basin is approximately 400 square feet. He also sent me an email confirming that to comply with the staff's recommendation, he'd be reducing the lower basin by 21%. This is not a great deal of space. I think that it makes sense under the circumstances to keep that extra room available. For those reasons, I'd request that condition be eliminated, and otherwise we'd request the approval of the application as presented. Be happy to answer any questions.
Any questions?
I have a question for our staff. I guess the idea that they're building basins larger than what is anticipated for the project that's under consideration for right now. Have we ever had a situation like this come up before? I'm just curious.
Annette Jacobson, no situation like this on the Sacred Heart main campus where the Jewish home for the elderly used to be. So there was a building there that got demolished, and they were proposing 2 dormitories. At that time, they had to build a detention basin. And at that time, we already knew they were going to build 3 more dormitories across from the 2 dormitories that were going to be under construction. At that time, we said, build the detention basin large enough to, not to just accommodate the 2, but to accommodate the 3 more. But that was an already disturbed site where the Jewish home had been already built and demolished. So we knew something absolutely was going to go there. And staff had actually recommended they make that basin bigger. But those dorms were to be built the exact next year. It wasn't a long term, it wasn't an unknown project. So we felt it was directly related and we knew what size it was going to be. This is an unknown future project. And I don't see any need for that. I can't recall another situation like this.
Okay, thank you.
Just on that point, Ms. Jacobson, is this basin interfering with a wetland as designed?
It's close to a watercourse that comes down the hill. So interfering or close to, it's unnecessary disturbance, but it would be easy
Well,
to expand the basins in the future.
My question is not, is it disturbing a wetland or is it disturbing a watercourse?
Is
I
it
mean-
harmful in any way?
Yeah, I mean, our job is to protect the wetlands, and if they want, I don't know why they can't build the thing 3 times as big as required if they want to, as long as they're not interfering with the wetland. I don't see the mere fact that you're suspicious that they're gonna do something in the future. What difference does it make?
In this particular case, there's a species of special concern. There's the box turtle habitat that uses the upland and the watercourse area, so that within 50 feet of that watercourse is this habitat area. So this is going closer to that watercourse, so that it's unnecessary to be that close. They could relocate them farther from that watercourse if they were made smaller.
Well, I can see that what Mr. Fitzpatrick's going to say, and what I think may be going through several of our minds is that we've already made the judgment on this commission that by setting our regulated upland parameters, how close you can come to a wetland or a watercourse, and if they're not going inside those parameters, why should we be making a case-by-case decision? You should be making it, I mean, we have to have a standard, and if they meet the standard, what difference does it make how big the darn thing is?
The upland review regulated area in this area is 144 feet.
Yes. So is this within the regulated what I'm asking you, is this basin within the regulated upland area?
Yes.
Fine. Okay. Mr. Fitzpatrick, I know you're bursting to talk on that.
One point, Mr. Chairman. The regulated area in this instance, Mill River, largest in town, 144 feet, is off a stone-lined, man-made drainage ditch. This is not the Mill River. Please keep in mind the nature of the regulated area we're talking about. This is a drainage ditch. There are several of them coming down the hill from the buildings that were built in '71. It's a stone-lined drainage ditch.
All right. Any questions? Are you going to take part? Do you have questions? Nope. Any questions from the commission, comments? Anything else we need from Mr. Fitzpatrick? I did think that one of the reasons we let it open was that your soil scientist or your engineer was going to come back with a calculation. I thought of just what the square footage is that we're talking about, how much oversized this is in square
It would
footage
be a
of the
reduction
basin.
of the lower basin
Yes.
by 21%, which my recollection is approximately 400 square feet, half the size of this room, maybe less.
Anything else from anybody? Have we had any? Is there anybody online that wants to be heard?
No.
No.
We'll just, what? I would just ask that question again, Mr. Chairman.
What's that?
I would just ask that question again.
Okay, is there anybody online that wishes to be heard? There's no one you need to unmute, no one's sending in here asking to be heard or making a request. And I think I asked this already once, but we didn't get any input from any neighbors that, or anyone else that was interested since the last hearing.
That's correct.
All right. So is there any reason why we can't close the hearing?
Mr. Chairman, can I just
Maybe there
address
is. Yes?
the two items that Mr. Fitzpatrick had referenced in the, that we had agreement on, just the two conditions?
I'm sorry, I'm not sorry, what you doing, Annette? I don't, do you have, you have a couple of documents that you want to put in the file? Is that it?
Unfortunately, I don't have a document. There were 3 total conditions that
Yes.
Attorney Fitzpatrick had concerns about, and now it's down to the one, but I didn't know if you intended to vote on it. I wanted to just give you some phrasing for 2 conditions.
Yeah, you might as well, because then if we're discussing it, Mr. Fitzpatrick, this will give him a chance to see, to comment on the language, which is always helpful.
Okay. The only condition that we're having concerns about is condition 1F. F as in Frank, so that there's no, I recommend no change in that. Obviously, Attorney Fitzpatrick would like that eliminated. The other condition is condition 2. And I believe we're in agreement on this, so I would recommend that it state that all the this is regarding invasive species control, and that I recommend it say that all the wetland and watercourse area plus 50 feet in all disturbance areas, all the areas that they propose to disturb, that they can control all the invasives. So basically where they're disturbing, plus 50 feet, they control invasives. And for the rest of the property, they just control Japanese barberry and vines. So it's limiting what I had originally put in that condition. And I believe that's agreeable to them. And then condition 4 on
Just
the,
let that just, is that, does that wording,
That's
is that?
agreeable, Mr. Chairman.
That's agreeable, okay. And Sarah, you've been able to take that down? Okay. And then Annette?
and then condition 4 was related to the easement for the stormwater basins. And I now recommend that there was concern about the language for the easement covering the meadows and the upland woods that relates to the drainage in the easements. And that language related to the meadows and the upland doesn't have to be in the easement. It could just be in that post-construction stormwater operation and maintenance plan.
No objection to that either, Mr.
Okay. And again, Sarah, you have that down? Okay. All righty. Anything else, Annette? Anything else, Mr. Fitzpatrick?
Anything else, Mr. Chairman? Would appreciate a decision tonight.
Anything else from the commission? Okay. All right, then I'm going to close the hearing down. So you're going to have 6 people. You can vote, I can vote. Charlie, so we got, I thought we had 7 of us here. Am I miscounting here? 1, 2, 3, 4, 5. Oh, 6, yes, of course. Okay, and then Felicia, can you vote on this? And did you familiarize yourself with the record? All right, thank you. Okay, then I'm going to close the hearing at this point. All right. Now, we skipped, Felicia, I think you wanted us to touch on something, didn't you? You want the report on the monthly wetland business update. Do we have that?
We're
Yeah,
busy.
you want to? We'll finish up the other stuff and we'll come back. All right. Give time to marinate a little bit. Did any questions or comments on the form, on the information that we got on the business update?
spring 2021.
All right.
Our famous clan check, now Bragg, Larkin. What, will anything ever happen on that?
No, not during the remainder of my term on the commission, that's for sure.
I don't know.
I'm just curious.
I gotta hope that it's not getting any worse, but it may be a long time until someone has to develop it, and then at that point,
What about Tuller?
what about Tuller? Where's that? Oh,
That was the,
yeah.
wasn't there a school there at one time?
yep, the Tuller School,
Yep.
yes. What's going on? Yeah, what does that matter on Tuller Road, Brian?
Is that the one?
That's a one-house, some fill in their backyard.
Yep.
Mm-hmm.
That's near the Serenity Lane off, Tuller
Yep.
is off Fairfield Woods.
So I need to follow up on that. So I need to follow up on that. That's kind of been resolved. We're having discussions with them about doing the mapping of the wetland to see where they need to remove fill. But that's something I need to follow up on.
What
Okay.
was John Street?
That was a minor, they had a wetland area that they replanted a couple of years ago. That's actually pretty recent. It was a mitigation area. I think the house was sold to new people and they came in and cleared all the plants out. So we're requiring them to replant that area.
Okay.
Oh.
Right,
All right,
thank you.
and that's why we have woods instead of meadow in the
What, one man's wetland restoration is another man's eyesore.
Yep. All right. Fine. Okay, we want to take up a couple of matters now. We want to go first. I think Sacred Heart might be the easier of the matters. Sure. Do we have, the only real, I'm going to take it that we generally are, I'm operating on the assumption that we're generally in favor of granting this application, subject to several conditions, and the one condition is, that's at issue, is how big the detention basin should be. Is that a fair, pretty fair statement? Do we have any discussion on the size of the detention basin?
I don't think that that requiring reduction of the size of the basin because it's oversized is something we can do. It's the existing plans do not cause adverse harm to the wetlands, and nor does it cause the mitigation measures to fail either. So I don't know how we can deny, I don't know how we can approve requiring condition 1F to remain.
Nelson? Nelson, you got to use your microphone.
Yeah, I think that the pond size can stay the way it is.
The way it's proposed?
The way it's proposed. I don't, sorry on that, but.
Charlie, any thoughts on that?
I have it in my notes from 49,000 to 40. It's like it was mentioned, was it 20% smaller? I mean, I just sort of, Annette did raise a good point that will it function as it should with a larger area? But
And Kathy?
My interest was that it is unusual to approve something larger than need be. I mean, if you want to reduce any sort of disturbance and leave the area as it is for the project that is in hand, making it larger without anticipation of anything going on. I get the dorms, why you would do that. It just seems a little, I've never heard of really that being done. Maybe that's not such a bad thing if it's not going to have an adverse impact on the wetland, might on the habitat that is out in the wetland. A little conflicted on that part. I've not seen that done. That's somebody's come in and said, let's build it bigger. Why is that necessary? I'm not sure.
Well, okay, and my thought on this was that it kind of is common sense that the manifest destiny of this site is to have more building on it. If there's more building required, there'll probably be required more of a bigger detention basin, and why not build it fairly big now, so you don't have to run a tractor in and a bulldozer in to make it bigger and ruin what you've already put in with the plantings and all. So I just think I think that is almost by definition a feasible or prudent thing to do, is to make the thing oversized. That's just my thought. We ready to vote on that, or want to discuss this issue a little more? Charlie, you look like you might have some comment. So maybe I'll just call a question, is who's in favor of leaving the catch basin, the oversized catch basin, the oversized detention basin as submitted in the plan?
I'm in favor of that.
Okay, so that's 4, and you're not uncertain, or? Yep. And Charlie too. Charlie too. So is that everybody? Yeah, I'll go. You don't have to. No. Okay. All right. Okay, so now having said that, do we then have, are we all in favor of approving the application as submitted with the 2 conditions agreed, with all the conditions agreed to by the applicant and the oversized detention basin? That's the question. Does that make sense to everybody? Are we missing anything there?
But we're
Jen?
deleting condition 1F, right?
Deleting 1F, yes.
Yes, I'm in favor of that.
Okay. Well, why don't we just go through the old-fashioned way and say, are we all in favor of the findings of the commission as proposed in the staff proposal?
Aye.
Yes.
Yes.
Okay.
Yes.
Is one of those findings that the basin's too big? If so, I guess we'd be in favor of all the conditions except that one. Okay. All the findings of fact. And then are we all in favor of approving the specific and usual conditions
Yes.
except 1F?
Yes.
And then are we all in favor of approving the plan overall with the changes we just made to it?
Yes.
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 All in favor? Okay, so I think you've got your approval. Do we miss anything there, Mr. Fitzpatrick? It gets confusing. Mr. Carey, we get everything?
Correct.
All right. Okay. And then that brings us to Fairfield Medical. I don't know about Fairfield Medical here.
I have to say truthfully, I'm a little confused.
Oh, okay.
Me
Okay.
too.
Me too.
So I just want to do the right thing, okay? Obviously, we all do. So,
My recommendation to the commission would be take no action tonight. It would remain on the agenda for deliberation if that's needed at the October 8th hearing.
And it's the idea that the court hearing would be resolved by that time and we could do it all at once?
I hope so. It'd become a moot point. They would try.
Yeah. I would agree with that, yeah.
So
I do too.
Don't deny the application in front of us.
I think you can deliberate when that time comes. You heard the hearing, it went through hearing. It's kind of an abridged matter for the entire project. I think taking action on it one way or another tonight is just, I mean, you could wait a month and it's up to the commission.
I concur with Brian, if that makes any,
Okay.
yeah.
Wait a month, but we're not allowed to under the law to continue it.
Can't continue the hearing.
Well,
And this isn't, they could close the hearing and there's still 35 days to vote, yeah.
Right, so
Yes,
we would close the hearing.
The hearing is absolutely closed. You closed it earlier this evening, but
Yes.
now you have 35 days to make a decision.
oh,
Okay,
okay.
I get it.
What I was asking.
Sorry.
That's.
Done.
It's obvious,
Yeah,
but it's
okay.
hard. It takes a while.
Sorry.
Yeah, all right, fine. Okay, well, so the consensus of the commission is that we are going to not take any action on this tonight, correct?
Correct.
All right. Yeah, we would, wouldn't we? All right. Is there anything, any other? Sarah, do we got any other that we're missing? Anybody else have any other? All right. Nice to see all the commission members I haven't seen in a long time. All righty. I'm going to close the hearing for tonight.
I see you on social media.
This session is no